Hey Brian, how are you?
I'm good. How are you?
I'm good. I'm glad you decided to come and talk to us today about the agreement to sell in Delaware.
Well, this is a redo.
I don't know. We needed to let
I
everybody
mean,
know.
we can be honest.
I mean, okay, we're being honest. This is a redo. We had some technical difficulties, some internet snafus.
Hmm.
So
As
to
one does.
yes. So today we're going to talk about the agreement to sell for Delaware for residential property. I'm Tiffany Rademicki with the Buy Sell Rent team, and
Brian Regan with Parkway Law.
all right. So from here, I'm going to let you go full bore.
Sounds good. All right. So everyone has seen the agreement of sale. Um, if you haven't, I don't know why you're here, but hey, welcome to the party. Uh, but what I recommend is that you take the time to go through the agreement of sale without the context of a transaction, just to familiarize yourself with the agreement of sale. It is 9 10 page document. That's not including addendums. That's trying to do a lot. There is a lot of details and minutia in there it's really helpful to kind of go through it without the pressure of a transaction to kind of be familiar with it from where sections are, where you should be looking at things, so you can give the best advice to your clients. And in approaching a transaction, I think it's helpful to not necessarily start with the agreement of sale, but just sort of however you catalog, prepare for a transaction for details that, not necessarily starting with the agreement of sale, but kind of that base information that you need to fill in your contracts. Start with that on the side so that you're, not necessarily filling in a contract, you're filling in what you know is the important details. Some of the important details that shockingly get forgotten are the correct names. So that's section one of the contract is names and addresses. You know, people will get their names wrong. Most common thing is someone who goes by Jim or Billy when it's actually James or William. Uh, you'll want to check with the client to make sure you have the spelling of their name. If you have any concerns and it's a finance transaction, you can talk with the loan officer to make sure that what they have matches up with what you have. In a finance transaction, when they do their pre-approvals, they will typically pull um, basic sort of, a credit report, which will include social security numbers, driver's license. So they'll have the base information that you need to fill this out. Um, and on your sellers, you just want to be cautious when you're dealing with an estate or a trust to make sure you have that information correctly. You can always check with the estate attorney, ask for copies of relevant documents. And then with your LLCs, your corporations, again, ask for relevant copies of documents so you're in the know. Sometimes people don't want to turn over some that personal information, but as a practical matter, uh, it's necessary for the transaction. The attorney's office, myself, I'll be asking for that information up front from sellers. So the sooner they give it to you, the sooner you can give it to me, and the transaction can be running smoother.
I have a question.
Go for it.
I see on the agreement to sell, it says seller one and seller two, and there's no space for seller three or four.
Mhm.
What is the maximum amount of people you can go under contract with to be listed on a agreement to sell?
There's not a maximum number. So the form only allows for two parties to be entered.
Mhm.
Uh, you could maybe finagle some of the form to add more people just from like the base document. At that point in time, if you have more than two people, you're going to want to do an addendum. And again, you maybe do some creative sort of docu-signing management where you can actually then put their initials in to be able to initial and sign everything as one. But you'll probably want to do an addendum or be generating a separate signature page so that you can add those additional parties.
Okay.
That you can run through those convoluted situations, particularly in an estate sale where it's not the estate selling it, it's all the individual owners. I've had a estate sale that had, I think, 12 people on it. Made for an interesting settlement, obviously, but you want to be cautious and make sure you're getting that information. And then it, to a certain extent, it is do what needs to be done to make sure everyone's listed and everyone's signed. And whether that makes your 9 page contract, double that's what you have to do to get everyone signed and on the same, in hitting the same spots on the agreement of sale, so it's fully executed. So there's no sort of wiggle room. There's no question about everybody having signed everything. So sometimes you have to do some extra work, whether that's just a basic addendum and with listing the additional parties and reaffirming all the terms
Hmm.
is an easy way to do it. Ideally, you'd like to have, if there's a third or fourth, you're able to, manipulate the DocuSign to add in those extra parties in there so you can do it all on one document. Um, that's not always possible, just based upon,
How DocuSign is set
how
up.
DocuSign's set up
Right.
and individual agents, technological capabilities. You don't want to give yourself a aneurysm just trying to mess with DocuSign. There's simple addendums you could do
Okay.
that you're not reinventing the agreement of sale. You're just saying, hey, this third party is another person to it. And you'll see that with buyers too, because sometimes you'll have multiple purchasers where some of those, again, you could do a basic addendum typically. With those, with strictly with a buyer, because we're dealing with a more often than not a lender, I would just sometimes double check with that loan officer to sort of say, is there a particular way that the underwriter needs to see the contract?
Yes.
Because, the seller can just sign the addendum and everyone's usually going to be okay.
Hmm.
With the buyer, they're just, a lot of times the underwriter is going to want more. So
Or they only want to see the people who are listed as responsible for the mortgage
yeah,
on the
yeah.
actual
So it
agreement of
could, it
sale.
can show a couple different ways and you can do it a few different ways. So
Okay. So section two, so just to recap, if you have more than two sellers, more than two buyers, you can do an additional addendum and create a signing page. That way everybody is agreeing to all the same terms at the same time. Section two, we're talking about the parcel number or the tax ID number. I'm sorry.
and just try to make sure everyone's address is right. Don't just
Okay.
assume the seller lives at the property.
Yes.
If you're selling a property in Wilmington and your guy lives in Maine, don't put Wilmington as the address. I mean, we do so much of our work email wise and communicating with sellers because that's just how modern business works. But there are formal mailings that will go out, and having the information correct the first time we get it, would certainly make things a lot easier for us. So,
Okay.
um, pretty straightforward, but it gets lost.
Yes. All right. So parcel number or tax ID, legal, legal description.
Yes. So your safest and the most common thing you will do is just put the county parcel number on it, and you'll use the 911 address. That's usually what's listed in the online listing.
Hmm.
Um, Run of the mill, straightforward stuff. Uh, you're not typically going to have to add anything outside of that, other than the parcel and the regular 911 address. Parcel number, excuse me. If you get into a situation where there's not a readily available 911 address, then you're kind of looking for additional items you can put in there. If there's a description of the acreage, that's very helpful. Again, including assuming you're including the town, zip code, and everything in the county. If there is a lot number in a community, so if you're in like a builder transaction, typically they have their own agreements of sale,
Hmm.
which is an entirely different conversation from the basic one, which we're not going to touch. But sometimes in that situation, there's not a 911 address that's been generated for those properties. So it'll just be a lot number in this subdivision, and that's a pretty adequate thing. You do not want to use sort of just, near Route 50 and Route 7. You kind of want to add more specifics. Sometimes there are some pretty lacking ones. You see this more often in Kent and Sussex County, but you can kind of cross-reference what's in the online listing versus what's in the county records.
Hmm.
Each of the counties has their own parcel systems that you're able to look at. So for Newcastle, if we just search Newcastle parcel, everyone please don't make fun of if I mistype anything. You'll be able to search, parcel number that you have, the street number, street name. You can search by subdivision. Um, and Newcastle, once you're into it, and all the other ones, both for Kent and Sussex, which I'll pull up those now, also have mapping systems associating with them. So if you needed to, kind of pull up what you have in their system versus what you're seeing online in your online listing, then you'll be able to kind of cross-reference that from a mapping standpoint, which I usually find to be helpful. But it just depends on your person. But I know that everything is supposed to be online in the online listing, but obviously that isn't always the case. So, you want to be able to cross-reference something. And this is
Mhm.
a particular concern if you're dealing with multiple parcel numbers potentially.
Mhm.
And that's also a situation where you could, if you have multiple parcel numbers being acquired, where there could not necessarily be a 911 address for an adjacent or nearby parcel. Again, if you're including the parcel number and what's information is being provided here in the county, either Sussex, Kent, or Newcastle system for those parcels, you'll be able to check that and have some legal description to describe it. The best thing is just going to make sure you get your parcel numbers right. Those do get wrong occasionally, but
And we fixed that with
yeah,
an
and it's
addendum.
and it's just usually just an addendum to fix. And I mean, most things you can fix by an addendum in some way. You just, some things you really don't want to try to be fixing later. From a practical legal perspective, it's just not a good idea to try to revise later because it could cause a renegotiation of the contract, which is what you want to avoid, as opposed to, hey, we're just going to do a basic cleanup of the contract.
So,
But relatively straightforward up to the property. My biggest recommendation for agents is to familiarize yourself with what the county systems are. Um, I know we're just talking about Delaware, but obviously, if you're outside of the state, everyone has, wherever you operate, try to figure out the government websites. They all operate a little bit differently. And they're just really good tools to be able to get a better understanding of the property, either from a legal description perspective or, get an idea of the subdivision or anything else like that. I think it's extremely helpful just to have your own knowledge base to be able to cross-reference this. And it's true for listing agents as well. If your seller's giving you information on a property, it doesn't hurt you, it doesn't harm you to just do a quick double check of what you're being told so that, your listing's correct, because obviously that's extremely important. Um, that's pretty much it for the properties, though. Payment terms is the next one. Uh, this is relatively straightforward. The
before
only
before you go on to payment
yes.
terms, we have the parcel number.
Mhm.
Sometimes what I see is I'll see the parcel number and then I'll see that they forgot to enter the 911 address.
Mhm.
So, just because you put the parcel number in doesn't mean you get to skip the 911 address.
No.
So please enter that as well
Yeah.
in DocuSign or in Dotloop. So in DocuSign, the boxes are very specific to what has to be in them. You'll see property address one, that is the house number, if there is a directional, and then the street and the type of street or road or type of, I don't want to say runway,
Yeah.
the type of street,
Yeah. It's
road,
fine. Yeah. Just
lane, such and such that it's
try to
in.
give more information rather than less.
The second box is always going to be if there's a unit number, is if it was a subdivision, that would be that extra part of the information if it exists. And then the third box is going to be your city, followed by your state, followed by your zip code. Please don't omit this information. Um, a lot of times, if you're sending out a contract and you're putting in an offer, what'll happen is the agent that's receiving it is saying, "Oh my God, they didn't even write this up. They didn't even take their time. I'm not even sure that, I'm going to make it high on my priority." Yes,
Mhm.
they're going to submit the offer because they're required to. Each offer that is submitted has to be presented to the client. However, they may add their own opinion because your contract wasn't completed properly. So
Yeah.
just
Absolutely fair.
yeah, just make sure that you're putting all the necessary and required information in your contracts. You don't want to rush through things like this.
Mhm.
And then payment terms. I don't
I
want
actually have
to.
another thing on the property. So
Oh,
you keep giving, if you let me think about it, I'll give you more thing. It's very quick. With the parcel number, what I'll just say is don't try to make sense of necessarily all the counties' dashes and dot systems because they look different in each county. So if you end up just having the numbers in the listing, like that's going to be enough. But Kent County technically has a both numerical and alphabetical system where the beginning technically has both a numerical representation and a letter one. Don't try to like get yourself wrapped up in like where does the dash go, where does the dot go? Because Kent's are very weird.
okay.
Um,
So
Newcastle, Sussex are pretty similar to each other, but
it doesn't
it's
matter.
yeah, not so much. Like if all the numbers are there, we're good.
Okay.
But just don't get too concerned in that.
With the periods, the
Yeah,
dashes and stuff.
payment terms. I mean, this is relatively straightforward. I only have two major issues that I see here. Um, Purchase price. When you do a oh, now I'm blanking on it.
And offer.
No, not an offer, but when you do the price goes up. Sorry, I'm really blank.
Escalation.
Escalation cost. Thank you. I'm blanking. Sorry, guys.
And he's
Uh,
supposed to be the smart
yeah,
one.
I know. When you have an escalation clause and the purchase price changes, come back to the first page of the contract and update the purchase price. Don't say, "Oh, well, there's an escalation clause and it's this." Like, don't email me. Don't send the contract and say, "Here's the contract. Oh, by the way, there's an escalation clause and the price is actually this." Come back to the first page, scratch it out, put the initials next to it, and make sure it's on the actual first page of the contract because you want to be able to look at this first page and without knowing too much else, you at least have with absolute certainty who the parties are, what they're buying, and what their purchase price is. Too often we get an escalation addendum where they say, "Well, refer to the escalation." I was like, no, 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 no. Don't wait. Don't let somebody else paint the picture for you. Put it together at the end before you actually finalize your contracts.
So what you're saying, so I understand
Sure.
because to be honest, I'm not sure I really understand
Okay.
when you say come back because if you're doing an escalation clause, you're
Mhm.
submitting the contract with the base number. So like here's the minimum.
Yep.
Let's say it's $500,000
Hmm.
and you want to escalate to 580 in
Hmm.
increments of $10,000.
Sure.
So you're going to put 580 on the contract. You're going to do a separate addendum that says max price to be 580 increments of 10, over each additional offer. And you're going to ask for proof of those other offers on that
Hmm.
escalation clause. What usually gets signed is, okay, we have the contract that normally gets initialed. Then we have the addendum, which also gets initialed and signed. And then the supporting documents saying, here are the other offers that support you going to, let's just say 570 instead of the
Sure.
580.
But what I'm saying is I've gotten contracts that say in section three, $500,000 purchase price with an escalation clause addendum being checked. They send the escalation clause addendum and the purchase price is actually 580. But the front page of the contract where everyone starts with this document in this first page,
Okay.
it still just says 500.
Okay.
So
Okay.
for me, it's a lack of clarity and that it's not hard to make sure that if the purchase price, if the escalation goes all the way up to 580 and that's the purchase price,
Okay.
I want to see that on the front page of the contract for me. But
So,
I don't know people do that escalation clauses differently and sometimes how they operate is differently. And this is not necessarily a guidance for how you should do them.
okay.
But for me, at the end of the day, what the purchase price needs to
Mhm.
be on the first page of the contract.
Okay. So I mean, it's possible to go back after everything is all said and done because
Mhm.
it may need to be cleaned up anyway.
Yeah, it's a
So,
cleanup thing, but
right.
for me, it's an extremely important cleanup thing
Okay.
because, like I said, from a strict contract standpoint, right at the beginning, I want to know what the purchase price, who the parties are, and the property. I mean, that's the definitive three of the four corners of a contract. Let's get it all right in front of us because my problem is, hey, I got the contract, I know it's 580. What if on any finance transaction, how many different people are touching a file for
Hmm.
a borrower, excuse me, and it just takes one of them to not see the escalation clause addendum,
And now we're
and then you got fire alarms in the underwriting, and obviously, the whole goal, the loan officer's goal is always no fire alarms, the underwriter, but you got to do sort of some of the necessary things to avoid that. And that's
okay.
an easy cleanup thing for me.
Yeah. So what could be done is once all the terms are agreed to, you can clean up the sales contract by putting in the new sales price next to the old sales price and having all parties sign. That makes it a clear.
Yeah. For me, I
Okay.
think that makes a lot of sense. And the only other thing with payment terms is when you're providing the deposit.
Yes.
Um, you know, Tiff and I have talked about this before, where if you fill nothing in, it's assumed that you are submitting this offer and you are ready to give the deposit right away.
Yes.
And more often than not, people can't just get to the bank to get, a cashier's check. And so many banks don't even have physical locations, so then you're dealing with the online wire, and that's its own thing. So, always give yourself a few days, whether
Mm-hmm.
it's 3, 5, 7. I think after 7, people get a little bit
Mm-hmm.
worried.
Mm-hmm.
Even 7 may be too long for some. I think 5 is a good sweet spot. 3 is, I think, more than fair usually, but always make the mark that says this is when we're going to be doing it. Uh, Other than that, outside of those occasions where for some reason during the negotiations or it became necessary to put down an additional deposit, those are the only kind of really more important sections that I see.
Mm-hmm.
I will tell you, for attorneys' perspective, the agreement assumes that the listing agent is going to be holding the EMD.
Yes. It is
A lot of
so.
them don't want to, so they make us do it as attorneys.
So here's what some people here are some of the conversations I've had around who
Hmm.
holds EMD. It's customary that the listing broker holds the EMD check. That's one.
Hmm.
Well, I don't want the listing broker to hold it because if my client and the listing agent or my client and the seller get into a dispute over the listing agent, I want it held with the buyer's attorney. The reality is the EMD cannot be released until we have two signatures. So both parties have to agree
Yeah.
to whatever it's released to, whether it's released to the buyer, whether it's released to the seller, whether it's split in half, both parties have to agree. It doesn't matter who holds it.
Yeah, it really doesn't.
Right.
And the only other time is, you could get one signature, and that's because it went to litigation and a judge signed off saying where it's going to go.
Yes.
So the judge's signature counts as two in that situation, basically.
Yes.
So I can understand there could be a personal sort of preference there, but, the listing agent, and we'll talk about the escrow provision. Listing agent the broker is limited in what they can do,
Hmm.
and there's not a lot of, it's more of an emotional sort of, I want the deposit to be held by so and so than an actual practical, in real life, this is how things are going to play out. So it's not really a hill willing to die on. But I do say, as an attorney, a lot of listing agents have stopped wanting to hold deposits. Try to communicate with your attorney about that in advance if you're capable, if you're able to. I know they have done a couple of new, forms for the
Hmm.
benefit of attorneys for us to be able to hold it. It can be kind of a thorny issue without getting into all of that. The only thing I ask for usually is just give me a heads up, because I just don't want to have like somebody calling me because you guys signed a contract at, 2 in the morning last night, and he's calling me being like, how do I get the money to you? I'm like, who are you, friend? I don't know what you want me to do.
Yes. So,
Just communicate. That's an easy
yeah.
one.
And if the attorney is going to hold the escrow deposit, it needs to state that on the contract. Like these contracts exist for a reason. There are dates, there are provisions, there are directives in the contract that outline
Hmm.
how the contract is supposed to go. What I see a lot of times is, well, listing brokerage to hold EMD. Oh, well, we sent it to the attorney.
Yeah.
And then now the attorney saying, I can't accept your EMD because the contract does not stipulate that.
Yeah.
So make sure you're following the letter of the contract. If you're making changes, again, we're having a conversation about addendums. However, we don't even have to go through all these addendums if you put the right information in your agreement of sale.
Yeah.
Make it very clear. The listing brokerage is holding the EMD. The attorney for the buyer is holding the EMD. Everything else is outlined in this agreement of sale, whether it's going to be interest bearing, non-interest bearing, all that is already outlined in this section here. Inclusions in, do you have anything to add there? Because we're only at four.
No, no, we're really cruising along here.
Yeah,
I know.
I need to,
I'm gonna have to add some more time
yeah.
to my parking, so that's fine. I some of these are cruisers, you
Yes.
know.
Okay.
Inclusions or exclusions are pretty straightforward. It
Yes.
is don't and I really say this for buyers agents. For the buyers agents, I say don't just rely upon what's in the seller's disclosure. You know, rely upon your actual inspection of the property, particularly if you know there are some other additional items that you want to have included that were not. You know, make sure they're on there because if you don't include it there, it just defaults to what's in the disclosure. So if there are additional items you want to account for, you know, say yes. If there are going to be additional items that you want to say no to, you should be marking it that way. I would also say you should probably be trying to communicate some of this, either, you know, whether formally or informally to the listing agent of like, hey, we really don't want X, Y, and Z, or hey, we want
Hmm.
this.
Hmm.
Um, because some of those can even be, you know, personal effects where you actually need to be including those in the section below where it says additional inclusions or exclusions. Um, but just something to be sort of, you know, don't just gloss over this is my main thing. And listing agents, that's my other thing as far as like if someone hasn't communicated with you, but there's a box check that you didn't expect or that you didn't do in your seller's disclosure, but you signed the contract. I don't care what's in the seller's disclosure. You agreed that they get to have the, you know, drapery and curtain rods.
Yes.
And you really wanted them. They were your grandmother's, you know, drapery and curtain rod.
Hmm.
Well, then you need to do an addendum at that point to get that cleaned up, but you really don't have a leg to stand on from a legal perspective. So
Hmm.
it's worth looking at and considering and make sure you're on the same page. And then inclusions and exclusions, which follows right after this, is just that some of that flexibility. If something is not listed out here, you know, on is not on this list, then you can add it in.
Hmm.
If it's a personal effect, usually that's where we'll see, you know, sort of um, you know, TVs or, you know, kind
Hmm.
of furniture,
Yeah.
you know, or something like that. And don't just assume sort of if the online listing has it, you know, it's coming furnished or it's coming with, you know, it's going to include the porch furniture and that's just in the deal, then you'd want to put that in the actual contract as an inclusion and exclusion because then it means it's done, it's included, everyone's accounting for it. Because if it's not in the, you know, it's not in the contract. I don't care what the online listing says. I don't care what the MLS or whatever. I don't care what it looks like because I have to go by, you know, what's actually in the contract.
Hmm.
Uh, so
So
something to be cautious of.
So, agents out there, what I would suggest is when you're walking through properties with your clients and you're noticing different things, there is a MLS disclosure sheet in Bright MLS that you can take with you, or you can just make note of things like, hey, this property has a cooktop instead of a standalone stove, or they have a built-in. Built-ins are usually considered fixtures, whereas a standalone stove could possibly be considered personal property because it's not attached to the property. Now, I would argue that it is attached to the property because there is probably a gas
Yeah,
line.
there's wires and other things that hook it up, and it's
Yeah,
not just like a plug. Yeah, yeah.
exactly. But I say that to say,
It's better to be cautious than to just assume.
yes, walk through the property, make notes of different things. And if your client is walking through the property and they keep talking about a chandelier that's there, you want to make sure that you, as the agent, make notes about that chandelier because nothing more devastating than going to that final walkthrough after you've been under contract and you're scheduled to close the next day, and that chandelier that your client has been talking about is not there. And then you go to check the agreement of sale and then you did not include it. I've seen situations
Yep.
where that has happened, and the agent was then responsible for replacing the chandelier because the client made it very, very clear, and the agent failed to put it in their
Yeah.
agreement of sale.
Chandeliers can be expensive too.
It was a very, this particular chandelier, I want to say it was somewhere around $1,000 or so. So yes, it was a very expensive learning lesson. Don't learn that lesson. Take the
Mhm.
lesson here that we're telling you about. Walk through the property with a pen and paper, making notes of things, whether the property has a dishwasher. Sometimes I have seen where on the seller's disclosure, it doesn't say anything about the dishwasher. You get to the property and there's a dishwasher there. Whether it's new, old, whatever it is, just make notes of things like this because oftentimes the seller's disclosure doesn't match what you're seeing in the property. So protect yourself and protect your client. So additional inclusions and exclusions, where Brian was just talking about inclusions. making sure you list those things that are outside of that list that you see here. So anything outside of this list that you see here, I think TV is actually on here, or wall brackets for TVs. Oh, mounted flat screens are actually on here. So an example may be, um, I see pool covers. I don't know. An example could be lawn equipment that's
Sure.
inside of the shed, and it may be listed on the public listing,
Hmm.
but it's not in the seller's disclosure. You want to put that information in here.
Yeah.
So, also, let's talk about leases and
Yeah,
rentals.
the forgotten provision of the agreement of sale.
One thing I want to, before you start,
You go.
is when you see solar panels. That is a lease to the property.
Almost always.
Almost always. So, yes, you can buy them outright, but you want to make sure that your client A can get approval because they come with the property. And you want to go through that process, getting the documents, finding out who the company is, and going through those steps. So, that is one thing that I see people think, oh, well, I don't have to worry about. That's the attorney's job.
Yeah, no. So Tesla with solar panels, they like everything is online. We can't submit it on their behalf. It has to come from the seller or the owner's account in their online account with Tesla. Like they used to let us be kind of facilitate it. Not anymore. We haven't been able to in a while. Where they has to it has to originate from the seller.
Okay.
It's from a listing agent perspective. You're kind of asking about some of these, and it should come up in your disclosures relative to any leases that you have. Uh, but it should be disclosed and marked there 'cause it's got to be dealt with. The solar panels is the big one. It's not the only one because storage tanks is can
Mhm.
be a big one. Those propane tanks that are one, especially ones that go underground, can be very expensive. Um, and there always can be, service contracts that people are unaware of. So it's important to inquire about those if you see anything about them. A little cheap for some of these. You should see some of these noted here as far as leased water conditioner, leased storage tank, leased security monitoring, leased solar equipment. So if it's marked here and it's included, then you better be checking here as it being subject to a third party rent lease agreement because it's a signal to both the attorney and the lender that this is a part of the transaction. It's got to be dealt with. And it's also a reminder because this is saying in here that the seller and the buyer are going to cooperate, particularly the seller, in the actual transition of these leases. This is something that can get forgotten. And then we get to the last week and it's like, well, I haven't done anything. It's like, well, this needs to be addressed. So
Mhm.
for your listing agent in your checklist as far as, what are we doing, to get to closing, that needs to go on your checklist. Same for the
Correct.
buyer's agent, where you are knowing to ask about it, at the onset and right after a contract execution to get details about how it's going to operate. Make sure you're following up the listing agent to say, like, where are we with the lease transfer, things like that.
Hmm.
And the first one is the 5A is just when there's a tenant. If there's a tenant, just mark this. So many times, there's so many times this does not get marked and it's a tenant property. And from a lawyer's perspective, I have no way of knowing if there's a tenant there or not. There's very limited, like there's one time with Newcastle County has like something on their website on their parcel view that says there's a rental permit,
Hmm.
but it's really hard for me to know if there's ever a tenant. So unless you're telling me up front with this section, I'm kind of playing a guessing game sometimes. And we ask and we follow up, but there's a limit to what we can ask. And I really, really don't enjoy when this isn't disclosed to us as the attorney and we get close to settlement and they're like, what are we doing with the security deposit? And I'm like, what are you talking about? They're like, well,
Yeah.
there's a tenant there. And I'm like, oh, well, if there's a tenant there, then that's a security deposit. We need to know where the security deposit is, who
Hmm.
has it. Is it the seller? Is it a rental agency?
Hmm.
What the rent is? Has the rent been paid?
Is
You
there
know,
a lease in place? Are they on month to month, like the
and
terms
you
of
should
them?
be asking for, as the listing agent, if you know there's a tenant, ask for the lease up front. It should not be as hard as it is sometimes to get a copy of a lease. So ask for that information up front. Buyer's agent, ask for that information up front. You know, these leases, what if someone just signed this lease, uh, you know, 3 weeks ago? They're in there for a year if it's a year lease.
So I have a question about
Go for
that,
it.
and I'm sure somebody out there may have a question too. If you enter into a purchase agreement with a seller of a property and they, let's say they don't disclose that there's a tenant there,
Hmm.
but they sign a lease after the purchase agreement has been signed,
Hmm.
is that lease still enforceable, or does that give?
So the lease is enforceable. The seller's breached the agreement of sale, and
Okay.
that's actually specifically provided here.
Okay.
I mean, it says seller will not alter any existing agreement. There's also a general,
Nor enter into
yep,
any new.
enter into. So, if they're entering into a lease without your approval as the buyer, they're breaching your obligations to you.
Okay.
So, that lease isn't going to be void on its face because likely you're dealing with a innocent third party who's got no way
Mm-hmm.
to know about this,
Mm-hmm.
but the seller's then breached. So then that becomes a different conversation. But knowing this sort of actual use of the property, I think is very helpful to sort of
Upfront.
kind of give you some upfronts about where that could be.
Mm-hmm.
Um,
5B.
5B, that's the solar panel one. We've already got
Yes.
it.
And
It's the same
pieces.
thing.
Yeah.
Just
Do
if
your
you
due
see,
diligence.
if yeah, do your due diligence and check the dang box so everybody knows what's going on.
Mm-hmm.
Part of the agreement of sale is just getting everyone on the same page.
Mm-hmm.
I mean, the part that's some of the job as the attorney is coordinating amongst all of the various parties. And that's a lot easier to do when we know who all of the parties are.
Mm-hmm.
And that's what we talk about, making sure all the sellers are listed, all the buyers are properly listed. If there's a third party,
They're listed.
leaseholder, they're listed or we're at least notified that they exist.
Mm-hmm.
Or a third party tenant, like just tell us that they exist so we can coordinate. If you're not disclosing information and the agreement of sale doesn't have everything relevant to the transaction, that's when gaps and holes appear and you end up with unhappy clients.
So what I'm hearing is, and I hope everybody else is hearing this, you want to do all your work up front. So just to take it back to the beginning and bring us current, gather all the relevant information that you need to fill out this document, everything beforehand. Also, it may be a great idea when you're doing your buyer's presentation, your buyer's consultations, that you want to do a trial close so they know what to expect. And you have also gone over this document and you know what questions could arise and you can deal with them ahead of time. So you're like, prepping your client for what's going to happen down the road. So, hey, during our buyer's consultation, we're going to go through the process as if we're truly in the process. We're going to do a trial lease, a trial close, so they know what to expect. So that's a good idea. Now, also reviewing your lease, making sure you have all your documents, making sure that you know who's a part of this, whether it's your buyer and your seller, whether it's your buyer, your seller, and a third party, being i.e. leasing company,
Could be Section
tenant,
8.
Section 8, whether it's underground storage, whether it's
Mhm.
solar panels, making sure you know who's a part of this transaction so that you can keep the lines of communication open. I promise you, if you do that, you will have a smoother transition. So now we get into the fun stuff, which is financing contingency.
Yay.
We all love finance. Listen, if I'm a listing agent and your agreement of sale comes across my desk and it says, yes, it's contingent upon financing, but none of this is filled out, or better yet, it's filled out, but it's filled out incorrectly. Maybe I see, the loan to value doesn't equal what the loan amount is. That is going to cause me to have questions for you.
Mhm. You go to the
So
bottom of the pile.
ex exactly, I still have to present it, but if there's multiple offers, you probably will go to the bottom of the pile because you're making me do additional work when you don't have to. So make sure when you are doing your financing contingency and if you're not 100% on this, call your LO, call your
Yeah,
loan officer. They will
absolutely.
walk you through. type of financing, you should know whether you're dealing with FHA, conventional, USDA, VA, whether you're dealing with the ARM, you're dealing with non-QM products. You should know at least that your loan amount is going to be determined by your loan to value. And your terms of years, it really also depends on what type of product that your client is getting.
Hmm.
Those are, if you're not sure of those questions, call your LO. Don't just fill out anything and say, oh, I'll fix it later with an addendum. Also, your buyer's mortgage contingency and your it says final date of receipt of buyer's mortgage commitment and appraisal if required by lender. This is your commitment date. By rule of thumb, I try to get my commitment date 25 to 35 days out. If we're closing in 30 days, I try to get it 10 days prior to the close dates. That way we give ourselves sufficient amount of time because there's always going to be some additional contingencies that need to be satisfied, conditions that need to be satisfied. You want to add anything there?
No,
Okay.
no. I mean, you pretty much hit the nail on the head. I mean, just make sure it's filled out correctly.
Mm-hmm.
Something to be cautious of if you know there's going to be secondary financing on there, like a DISHA.
Mm-hmm.
Usually two type of financing will be FHA plus DISHA or something like that. Just a notification because they are an extra party in the transaction and they can take time. City of Wilmington loans, City of Dover, any other sort of grant programs. You
Mm-hmm.
want to try to notate them in some way so everyone knows about them and they're not surprised. You don't want to, kind of be,
Surprise, we have to wait for DSHA
yeah,
approval.
exactly. Or you're seeing something on the, the final alta, like they're getting money from somewhere else that,
Mm-hmm.
they weren't aware of. So that's not ideal. The biggest thing I have for financing contingency is one, emphasize for your buyers agents is that this is their best protection for them and their deposit in this transaction, but it is wholly contingent upon them providing what they have to provide for
Cooperating.
their lender.
Mm-hmm.
The whole agreement is conditioned upon, a buyer cooperating with their lender, but you can't just sort of sit on your hands and not do what the lender's asking and then be entitled to the protection of this section. It can be annoying, it can be stressful, it can be all of the above. And the answer is that's what everybody has to deal with. And it's what you have to do to protect your interests. So, if they're asking for something for the sixth time, you provide it the sixth time. And you have to just kind of do some of that, kind of that in your buyer consultation, sort of explaining that when you go under contract, like
Mm-hmm.
a necessary portion of this is going to be your commitment to being involved in the loan process because it's necessary to protect your interest there. Uh, One thing I'll note for the listing agents is while the finance industry again protects the buyer and it's based upon them, complying with lender instructions, if there's a delay in the timeline, there is an obligation in this finance industry that you have to actually put the buyer on notice of a default if they haven't actually done, provided you a credit close and everything. If they're 3 days late and you say nothing and you don't provide any notice and then they provide, their full clear to close,
And you
you're
accept it.
good. You accept it. And you don't have a leg to stand on after the fact. Um, and so you have to be sort of just aware of that, you have to be on your deadlines for things. Uh, and that's something that kind of gets lost throughout part of the agreement of sale is that it can, um, you have to be taking affirmative action to get the benefit of, whether the buyer or the seller, you have to be doing something to get a result for yourself.
Mm-hmm.
Uh, One thing that I think people forget about is, and this is sort of about the exchange of information and having everyone on the same page. By this agreement, buyer explicitly is authorizing the seller's agent to know stuff about their transaction. And the buyer and the attorney is explicitly being authorized by both buyer and seller we get to know stuff. So
Mm-hmm.
do not play a game of hide information. It doesn't work out well. It just frustrates the process. And it's something where, yeah, it can feel a little more exposed is probably an exaggeration, but more open than what you would like.
Mm-hmm.
That's the deal. If you
Mm-hmm.
want to get a loan
Mm-hmm.
and if you want a seller to cooperate in that process, because the seller is going to have to cooperate for some of the,
Mm-hmm.
the lender appraisal or things like that, then you got to be all on the same page. And this is really important, as part of your buyer consult. And then afterwards is to, really hammer home with them the obligation to cooperate, but those timelines, you
Mm-hmm.
know, it,
Mm-hmm.
a lot of agents, the better agents I see, will, as a part of their initial communication, will set forth, and they'll give this to me, and I'm not even involved in a good chunk of this, is to say, here's the buyer, here's the lender, here's the buyer's agent, the seller's agent, the insurance company, the loan officer, and this is our inspection schedule date.
Yeah.
This is the date for a report to
Mm-hmm.
come over. This is the appraisal deadline. This is all of the deadlines get laid out in
Mm-hmm.
front, and this should be easy to do for everyone when you go through your agreement of sales. And that's also a significant part of preparing the agreement of sale is, and this is a better conversation for Tiffany and your loan officer, is to do realistic timelines
Yes.
for everything. I
Yes.
think people get a little um, hopeful in how they do that. And again, every listing agent wants every timeline to be, as fast as possible. And that's completely fair. If you're a listing agent, you understand it. But a lot of those timelines exist on items that are to protect the client, inspections for the home,
Mm-hmm.
the financing contingency. So, you know, give yourself reasonable time, but make sure everybody on your side of the transaction knows what your dates are.
Knows what those
And
dates
make,
are.
loan officers on the same page. What are
Mm-hmm.
the dates the loan officer has to hit his benchmarks for? So, because he knows that if the underwriting is going to take 48 hours, and he better have his file ready to go, you know, 72, 96 hours prior to the deadline,
Yeah.
whatever the case may be. So everyone's on
Mm-hmm.
the same page. Because if you're hitting your marks as far as those dates, you are protecting yourself.
So I'm just going to add communication, communication, communication. There is no agent that's going to be like, oh my God, I don't want to work with this agent anymore because they're communicating every single thing that's happening with this process. No agent is going to complain about that. They are going to praise you if you do that. So having that document, once you go under contract and the terms are agreed upon, you need to map everything out and have dates, and you should send that information out to the attorneys, to the LO, and you should also put everybody in contact. So we do what we call a welcome email, and it has the attorney on it, it has the lender on it, it has the buyer's agent and the seller's agent on there. If there's an assistant or a transaction management company, they're also on it. And we give contact information, whether that's some attorneys do not want you to give out their cell phone number. They prefer only email. Some attorneys, like Brian, doesn't mind if you give out his cell phone number.
For
However,
the most part. Let's
okay,
let's
for the most part.
let's
Okay. So what I'll say is know who you're dealing with, know what information they want out there, put it in an email and communicate that to every party part of the transaction. The other part that I think is super important to mention is Section 7, your settlement date. Sometimes now, this is not a big deal, but we're talking about completing your agreement of sale correctly. If you are settling a property in Kent County, but you want to close in Newcastle County, that is fine. If it's okay with your client, then it's okay if you're the buyer's agent. If it's okay with your buyer, then that's fine. If you're closing in Kent County and you put on your agreement of sale that you're closing in Newcastle County, but your buyer wants to close in Kent County, that's a problem.
Yeah, people get they're real sticklers for it. So we have an office in Dover and an office in Townsend. Um, so like those Smyrna, Clayton area closings, a lot of times it makes more sense to meet in Townsend. But people will be like, well, nope, contract says Kent. So we got to do it in Dover. And I can't really argue with it. I mean, we can make things more convenient. We can, we try to be helpful and creative, when it calls for it. But
Mhm.
yeah, that's something to be cognizant of, where you actually want to close. Something, the most common thing we see is, somebody who's buying a property either at the beach or maybe in Kent County, but they're coming from New York or New Jersey, and they don't want to do all that extra hour and a half drive or whatever, we're coming from Philly and getting stuck in traffic, and they'd rather
Hmm.
just do it up here at the KW office. That's fine. I got no problem doing that, but kind of putting it in the contract, and then, I mean, you can always send in an email like, hey, X, Y, and Z just want to close it in this office for our convenience. And again, we're used to dealing with sellers. I mean, I know the contract does explicitly say that we're all going to be in the same room and that's how we're going to close, but it also explicitly says the seller can make alternative accommodations, if approved, sort of thing. And it's almost always approved that we're going to work it out for the seller to sign however they need to sign.
Hmm.
But it's something to sort of be, have it figured out up front as best as you can. Um, Again, things can move, things can change, but it's just an easy thing.
Yeah.
My biggest thing with Section 7 is this is a seriously misunderstood section of the contract
Hmm.
because everyone kind of just reads up until the before. Unless otherwise mutually agreed, final settlement shall be held in blank county on blank date, or before if mutually agreed upon, and then they kind of just stop.
Yes. And this
And
is this is the part, if your eyes started to gloss over, this is something that you want to pay
Yeah.
attention to.
So I'm going to read it to you, which I don't like doing, but I will anyway. Because right after that, it then says it expressly agreed if a longer time is necessary to secure a survey, prepare the necessary legal and financial settlement documents, date of settlement shall be extended for a reasonable time to affect these conditions.
Can you can just
Plain English?
no, no, no. Can you read it one more time and
Sure.
then go into
All
plain
right.
language?
It is expressly agreed if a longer time is necessary to secure a survey or to prepare the necessary legal and financial settlement documents, the date of settlement shall be extended for a reasonable time to affect these conditions.
Settlement can automatically be extended to a reasonable time, is what I heard,
Correct.
without an addendum. Now,
Correct.
your lender, more than
Probably
likely,
ask for an addendum. Yeah.
and your attorney is probably going to ask for an addendum.
Yep.
But when you are on a settlement date and you've been going back and forth with your co-oping agent, and your co-oping agent says, well, today is the day. If you don't settle, I'm putting the property back online.
Yeah. No, that's not how that works. You're still under contract. The contract explicitly accounts for contracts being delayed. And the wishy-washiness is that it says unreasonable time. That is reasonable is different for almost every person. I kind of put it in like 3 to 5 business days is reasonable. Sometimes based upon circumstances that can be longer. Uh, you know, if you can't close on the Tuesday and they're like, fine, we'll close Wednesday, that's a reasonable amount of time, just a day. That's not a reasonable amount of time for like if something's not ready, and almost always this is from like a loan approval perspective,
Mm-hmm.
but it's important for the buyer's agent to know that, for like Tiffany said, for having that conversation with the listing agent to say, actually, this is perfectly okay under the contract. And it's also helpful for the listing agent to know and point out in advance as much as needed, because yeah, your seller might be teed off. And I understand, that reasonable can certainly look different in a case of when we have, back-to-back closings,
Yes.
selling and buying. I understand that, but
The contract does
it
allow for it.
assumes that it assumes it's basically going to happen, and that it can happen. So, we're not, the point of that is to say we're not redoing the contract just because we got delayed by 2 days, because that would be ridiculous.
Mm-hmm.
So you still under contract, I mean, you want to know at that point when you can actually close. Hey, is it going to be 3 days and then we're going to be ready? Cool. Then you can communicate that. You can put that addendum in place.
Mm-hmm.
Great. But contract expects it doesn't expect, but a contract allows for this to happen, and that's perfectly normal. And there's nothing, there's no default being made by the buyer because you can't close right on time. Uh, and now it gets really boring.
Yeah, so we
So
get to
yeah,
fly through this part.
we can cruise through with this.
Yeah.
This section here relative to the settlement time again makes clear that you as the buyer, there's going to be exchange of information with everyone. It does talk about the trade 3-day business rules,
Mm-hmm.
something to be aware of, but we kind of get to cruise here for a minute. Wire fraud is bad. It is pervasive. I will say We more and more have to request wires for transactions from an accounting, an ethical accounting standpoint, where
Hmm.
that's become the preference for a lot of law firms and the different bar associations. So we are having to request it more and more. What I will tell you is that wires don't work like ACHs. They are not immediate. It's not like a Venmo where like if I Venmo Tiffany $10, she would get a pop-up in within seconds. Wires don't work that way.
Right.
Wires can take hours.
And there's a cutoff
And
date on,
if
yeah,
I could say anything is if you get wiring instructions from a law firm, call them. Call the number that you have and do it because
not the number that comes. So if
yeah,
you get
the same
something via
number.
email,
Yeah, or make sure you call your agent and say,
hmm
"Hey, I need you to we need to confirm these together." And you call, because if some reason you can't find the number, make sure you are calling the law firm.
hmm
You are talking to a person there to be able to confirm that information.
and again, do not call the number that's on the email
Yeah.
because that's how these scams work.
Also, just just do yourselves a favor. If you get something and if you ever have any kind of like a flutter or any of like this is odd,
Then stop.
just stop. And you can also like, because again, they're really good at masking this, but just click on the actual email address that it comes from, because then it's going to pop up as being 17 numbers and letters at blah blah blah.com, and
Mhm.
you know it's a scam, but
Or
just
on
take your
quick,
time.
yeah, or on quick glance because they're getting more craftier with the
Yeah.
emails where, you may
There's a
have,
spelling error or something.
yeah,
Yeah.
a I, and it's because it's lowercase, it looks like a L, or, what I'm saying. And it looks like an email address. But again, if you have that any hesitation, like something doesn't feel right or feels off, or it's just a regular email, because wiring instructions, we try not to send them through a regular email. Usually they come through a secure channel.
Mhm.
Occasionally they will come from, because I don't want to say all the time, occasionally
It,
they
it
will
yeah
come
it can come through regular mail, but we say
verified.
call us to verify, and if you have any question, you can have your bank call to verify,
Mm-hmm.
because the at least on ours we have our bank and our bank location on there.
Mm-hmm.
So if you went into your Wells Fargo or wherever the case would be, and you said you had to send a wire, but I want to confirm it, Wells Fargo can call the PNC in Middletown and can confirm that the information for our account is right.
Okay.
So I mean, just some of those things you want to kind of you just want to be very cautious. If you are sending a wire, every like no matter what, just take a step back and just say, let me look at this. Even if everything looks right and you have no like,
Angst
tingles of
about it,
anything
right?
bad about it, I don't care. Take 5 minutes to just sort of go through the details,
And
make
verify.
that phone call and verify. Because wires, you were clicking the buttons and you're just kind of sending money out there, and
You can get it
there's
back
no
though.
guarantee you get it back if it goes to the wrong place or if you get scammed. It's
Yes.
just not fun.
So that conversation that we just had is more for you to be having with your clients.
Yep.
So you could take a snippet of this video and use that and play that in front of your clients. We're totally okay with it. We just want to make sure that you are representing your client and your client's interest the best of your ability. And you are providing all of the information to keep them safe.
Yeah.
All right. So, nine, time is of the essence. That means our dates aren't willy nilly.
That's number 8. But yes,
What did I say?
you said 9. It's
Oh,
okay. It
okay.
just
So,
means, yeah, it's what we said, why you set out all the dates, because they matter. I mean, notwithstanding relative to the, you can have an extension of time that's reasonable for a settlement date. That's true and that's always valid, but you still have to be pushing for that date. And all
yes.
the other dates are going to be strictly construed. And we can mention some of it. We talk about the inspection contingency, but like you got to hit your dates on there. And
Mhm.
if you do not hit your dates, then you leave yourself exposed from a liability perspective. So hit your
So,
dates.
failure to meet stated dates or timeframes may result in waiver of contractual rights or default under the terms of this agreement.
Yeah. Copy and
So,
paste the section out and send it to your client and say, this is as plain English as you're going to get.
exactly.
We got time frames.
All right, conveyancing.
Oh, this is boring. This is legal stuff. So it's in fee simple is almost how everything's owned. There's not a ton of co-op ownership in the state. There is plenty of leasehold subject to annual ground rent. So that's your mobiles or anything else like that. There are a few down in Sussex, and actually a couple in Newcastle, and that have like regular houses built on them, but they're on a lease. That's just checking the listing and make sure
Hmm.
that's correct. Sometimes people don't do this right. Like there's a in Lewis Beach in Lewis, a lot of those are 99-year leases that are like
Hmm.
$1 a lease. They're not strict fee simple. They get them wrong. We just it's the biggest concern for those because I mean a mobile is a mobile. Everyone can kind of see that for the
Hmm.
most part. But that leasehold for some of those, like that is a different sort of underwriting process that's got to be gone through from the lender's perspective. So, ask those questions in advance. You should start to see sort of when there are going to be, areas where you can expect to see some, co-op ownership or leasehold. I think is it Ardentown, I think is one where it's kind of a co-op. Or actually it's a lease maybe, but you'll see it in spots. It's very spotty. So you should be knowing when you're walking into sort of those areas, but check your listing, make sure it's right. If we got to correct it later, we got to correct it later. Biggest thing
Go
is usually a financing thing down the road to make sure it's everything's matching up from their perspective.
Go into public records. You should be able to find the information that you need. But
Yeah,
while we're here, pop quiz for those of you out there. Brian, pop quiz for you.
I don't want to.
Yeah, you're going to. What is fee simple? What do you own when you own a fee simple house?
Uh,
When you get the three branches of wood and I convey them to you, what do I own?
I mean, essentially, it's an absolute type of ownership where you are the sole owner of that uh,
Structure.
square, that structure, that box, that land right there. Um,
What about the ground?
you do own the ground. How far down you own, I have no idea, and I'm not gonna try to commit to that.
Okay.
Um,
What about
but
the air? What about a certain
so there
portion
is
of the air?
some portion of the air you are entitled to relative to the right to use,
Mhm.
like you can take your house higher. That's something where I don't necessarily have a hard line of where that caps. And that's also, from an air perspective, like, if the neighbor's tree is leaning into your air where you can prune that tree. Um, at the property line sort of thing.
Mhm.
That's where you'll see kind of tree law, which I don't do. So I can't give you any kind of tree law advice. None of this is legal advice anyway. This is just general sort of advice because I'm
Wait a
being
minute.
friendly. I got to do my disclaimers. I didn't do it at the top. I do
Sure.
it when I do it.
Okay. Sure.
Um, but there's some air that's yours, and if it's not explicit sort of ownership of the air, it's the exclusive right to use the air. Or and as you build up, yeah, you get kind of more air. But it's a
And
weird question.
always, I know.
It's a weirder answer, but it's a weird question.
Yes,
So I got you.
but always check with your township, your municipal, your city,
Or
or
county.
county. Always check with them because there's areas of Newcastle County that your air rights are limited because they are
Yeah,
by
by the
the
airport.
airport.
Yeah, that's the biggest consideration for
Hmm.
those air rights is, by an airport.
Hmm.
You can even see, quote unquote air rights being impacted in parts of Sussex and Kent when you are in agricultural farmland areas.
Hmm.
You don't necessarily have a right to the air not smelling a certain way at certain times of the year. And that is something that you just have to be aware of. That's a preference thing a lot of times, but
Hmm.
it's not like it's invading your ownership. And there's also various degrees on it, and there's nuisance law, and that's sort of a way down the rabbit hole. But
Okay.
yeah,
But just as a general synopsis, fee simple is you own
you're owning the land.
your
Leasehold means that the leaseholder owns the land, you
and you
own
own
the
the
structure
structure
on top
on
of
it.
it, and you're renting the land from them.
And then you have your co-op ownership. It's usually um, a a shared.
Yeah,
So co-op could be a building where everybody owns.
like a portion of it's kind of akin to a condo, but it's
Yeah.
not. It's I really don't see them very much. It's kind of like a large metropolitan area thing. Like I feel like it's a New York thing, if I'm being honest with you.
Well, they have them in Philly
Yeah,
too.
yeah, I know,
Yeah.
but I only think see it there. Uh we got to keep rolling.
Okay. All right.
This might be a two-part series.
Okay. We don't want it
This
to be
is
a two.
I know.
All right, disbursement of deposits. Remember, I was telling you earlier when you have disagreements with your co-oping agent over EMDs. Guess what? This section is going to talk a little bit about that because you need two signatures to be able to release a deposit. And except in the case of you have to go to court and you have to have a judge decide what happens to a deposit, then you only need one person to sign because now you have a court order on what is to be done with said EMD. Outside of that, we're not going to go into a whole lot of discussion unless there's something that
Yeah,
is
my
particularly
only
interesting.
discussion is that as far as they list out the examples of when the deposit can be dispersed, and that's it. There's nothing else. Um,
I do have one thing.
my only other thing, and maybe we're having the same as far as that broker provision to have it be released, don't do 60 days. Do sooner because you don't want this to drag on.
Right.
You know,
That doesn't
it's
make it happen, though.
no,
It
no,
just
because
says.
even by the terms of this, by giving the broker the right to, do a disbursement when they make a determination, they have to then provide a notice. And if there's any kind of objection, it ends up in court essentially. So,
Mhm.
it's not a silver bullet for the situation. The idea was that they'd be able to get these resolved
Quicker.
quicker, or on those rare, but they do happen occasions where a contract falls through and just nobody talks to each other, and then the broker is holding on to the deposit for and in for a couple of years, and you're
Hmm.
like, you can't hold this money forever. It's
Hmm.
not yours. You have to get rid of it. It's a process to protect the brokers to be able to get those funds out, so they're not in the middle of this forever. But it does allow for interpleader, which essentially just means the court's going to decide it.
Hmm. All right. Deposits held with non-brokers.
Yeah, so it's basically if we're going to hold the deposit, it's
Mhm.
just it looks different because the attorneys under the current sort of setup, we can't follow the broker provision because it says brokers, it's specific to brokers.
Hmm.
So that for whatever benefit of it is, we don't get the benefit of it. So we
Right.
could have money just sitting in escrow because no one wants to deal with it, and it could be
Hello.
annoying from an accounting standpoint. But
Yeah.
yeah.
All right. Transfer taxes, prorations, heating fuel. If you have a client who has an oil tank, whether above or below ground, it doesn't matter. You being proactive is a plus in this. You want to be able to convey appropriate information. That's what I want to say about oil tanks. Transfer taxes. What's the rate here? Is it different in each county?
It is. So
Oh,
no, it's the same in each county. So it's 4% across the state.
okay.
It is split 2.5 between the state, 1.5 between the local, either county or municipality. Uh, the biggest thing for me to note is not necessarily this section, but it's just relative to transfer taxes, that it doesn't look the same from a first-time home buyer perspective in each part of the state. It looks different in a lot of different ways. So the state one doesn't actually change. The state's a reduction of 0.5%. So that stays the same.
Mm-hmm.
But the local one looks different. So in Newcastle, they cap it at 400,000. Anything over 400,000 is taxed at the full 1.5, at least it's the buyer's portion. Sussex and Kent do not have that cap. Kent actually exempts it on both sides
Okay.
for
Buyer
the
and
the
seller.
local one. Sussex is just the buyer side. Uh, a lot of the municipalities do not have any kind of first time home buyer credit. Um, City of Dover does, Wilmington does, Milford does. Um, big ones that don't are Middletown has nothing, Smyrna has nothing. Um, I don't think Sussex is kind of all over the place, but in the unincorporated areas, in the county areas, it's relatively straightforward. Once you traverse into, I'm in a municipality now, I'm in incorporated property, not alarm bells, but you should know that there are some extra steps that you're going to have to be considerate of relative to how does the transfer tax operate? Am I still going to get a transfer tax credit from my client?
Okay.
There's more that I could talk about relative to that,
But
but
that's
and,
it.
and actually it's actually appropriate for the section because it's the prorations of things. But
Okay.
once you go into municipalities, you need to understand that you need to deal with municipal taxes now.
Mm-hmm.
So, and that's not going to be in the county's website for what they are. This has come up for me recently where the municipal taxes were not accounted for in the property listing, and it had caused a significant increase. So there was a lot of moving parts that had to be moved in order for everything to go well. But it's something that happened because we do prorate for those at closing. They get done. Most of the biggest concern here is the lender perspective with escrows, but
Hmm.
they all get dealt with as part of exemption as far as assessments and prorations and everything like that. But just have your information relative to what those necessary service providers are, so we can gather the information to get it prorated. The towns are usually pretty easy to deal with. We send them a request, they send us over the information.
Okay.
There you go. Wilmington's its own animal. Um, just being honest. But if you don't tell us about a propane thing or an oil tank reading, do not call me 2 hours before closing saying we got to throw something on there. I am not going to be happy.
Okay.
You're gonna have a problem because you have to redo the buyer's disclosure.
Okay.
And sometimes it took you had to pull teeth just to get everything from that.
Hmm.
So to try to change it 2 hours before or shorter time frame, that's problematic, and you may have to handle it outside of closing, which people do and don't want to do for a variety of reasons. But if you try to supply information to me right before we close, I'm not going to be happy with you. And your seller's not going to be happy with you that there's potential, because oil is expensive. You could have
Yes.
$400 or $500 of oil that they're entitled to credit for
Hmm.
that you forget to schedule it for. So find out who that company is,
Hmm.
and hey, put it on the seller. Just tell your oil company, I am terminating my service. I need you to do a reading. We're closing on such and such date. And yeah, they're not going to do a reading the day of, but they can do a reading 2, 3 days before.
Hmm.
You can have that information in advance. Everybody's on the same page. It's disclosed. There's no surprises there. But you show
Again.
up to the table with a slip that says, actually, the oil company says there's $400 in the tank. We need to add this to the settlement statement. You know what I'm going to say. I'm not going to say it out loud. I'm not going to say it when I'm being recorded, but you know what I want to say.
Yeah, don't.
Yeah, yeah.
I'm
I'm
glad you're
not.
not going to say
We're
it.
not
Thank
going to do
you.
it. We're not
Thank
going to
you.
do it.
So my point in recapping that is make sure you get all the information and have all your ducks in a row. Make sure you get these readings. You know what type of tank, whether you have above ground or below ground, how much is in the tank. Is the seller like I've had sellers say, I don't care about that. Like I just want to sell the property. I got X amount for it. They can have what's in the tank. And it could be $400 or $500. There are sellers that have said that. But then there's other sellers that are like, no, down to the penny. We
Yeah,
have $372.48 in there, and we want the credit for that.
yeah. And you want just have your conversations up front, so you're
Yes.
not finding out too late. Seller buyer to pay deed prep. This is in Kent and Newcastle. The buyer pays it. In Sussex, the seller usually pays it. It's a weird customary thing based upon location. It doesn't change a whole lot for the transaction. It's just only if things comes if seller retains their own counsel to do it.
So what I heard was it's customary, but it could be.
It could be,
So
yeah.
if
It's
somebody was
just
trying to enhance their offer, so two things. So this will go with transfer taxes and this section here. So if a buyer was trying to enhance their offer and they wanted to say, listen, I am going to cover the transfer taxes for both myself and the seller. That's going to net the seller more money, correct?
yes,
And in addition to that, I am going to pay deed prep.
yeah. I mean, it could move the needle for some people.
Mhm.
The transfer tax is going to be a better argument because it's a lot more
Yes.
money, but
Hmm.
it's something that I mean, almost always the buyer's going to pay it. And honestly, it usually, from my perspective, it makes sense because it means that my office is doing it and we're doing everything else in the transaction. Just have us prepare the deed. It's kind of annoying when we have to bring in another law firm to do a portion of it when we could just kind of control
Right.
everything. But
And it's another line item on the
yeah,
ALTA, correct? Title.
yeah.
Title is done. So I am licensed in other states, and this was a new one for me when I got
Hmm.
licensed down here. Title is prepared by the attorneys.
Yep.
There's no title companies here,
So
correct?
there's a so that's part of the problem is definitionally. So um, there are still national title companies that are involved, and they're the underwriters for they underwrite the actual loan. They're the ones that are issuing the policy.
Okay.
Title companies in other states kind of get an incorrect name. They're more like an escrow agent in another state rather than a strict title company. Because again, even those title companies like in Pennsylvania, they're usually underwriting for a national company is who they are licensed through.
Yeah.
And that's the actual title company that's in the back of all transactions nationally for the most part.
That's listed on your actual
Yeah, but so
policy.
yes, so
Hmm.
but for here in Delaware, it's an attorney state, so attorneys handle title preparation. Um, they can't see it. It's fine.
It's I hate when you keep cutting my face off.
Oh, okay, okay, whatever.
Okay,
You can get
continue.
over it. But we handle everything relative to the title. Title has to be good and marketable and fee simple, and it has to be insurable.
Hmm.
Um, I don't have this is strictly really boring stuff. If I can tell you anything helpful in this section, it's just that I always recommend title insurance. If there's ever a conversation that needs to be had with a client and they want to ask about title insurance, I hope you tell them that it's a really good idea. And I also, the other thing I say is, you can talk to a law firm about it if they
Hmm.
have questions. I'm happy to answer those. The only other thing I will note here, there's two things, is that just because you have title insurance doesn't mean there can't be some easements or other things. It's really common that you have an easement for utilities, whether
Utilities.
that is sewer, electric, anything else the same. That's pretty standard in your that's not standard. That is in every neighborhood you will have some kind of easement along some of the lines for utility provided provisions. There is a cure provision. If we find an issue, the seller has an opportunity to fix some things. There's like a 30-day time period for it. Uh, Usually we're working with the seller because we're the
Hmm.
ones that have discovered the issue. So we try to communicate in that. Really, it's an incredibly nuanced topic.
Hmm.
And a lot of my answers, if you have questions, are going to be on a case by case basis, or they are come find me in the office and talk to me about title,
Hmm.
or hey, we run into this problem with the title on this transaction. What do I think? Or I'm on the transaction and we run into a title issue and I go, here's the problem. And it's just extremely nuanced. It's
Hmm.
boring to everybody. I understand it. That's fine. I like it, and that's what matters. You want your attorney to actually be interested in the title of the property, but it's kind of boring.
Okay. All right.
That's it.
Most new agents are concerned about, well, when I'm talking to my clients, what should I tell them how they should take title? Should they be tenants in common? So my go-to is usually if I have clients who are unmarried and they are in
Mm.
love, I recommend, not recommend, I have all my clients who are unmarried that want to purchase property together have a consultation with you. That is
Yeah,
a
no,
requirement for all my
yeah.
clients. So
Don't
they know this is, I love you Monday, but it's Wednesday. And I'm like, oh, maybe not so much today. And I just want to be done with this. This is a business decision. This is a legal transaction that you're about to do. And it's not,
yeah,
oh, I'm just going to walk away and wash my hands. You still have responsibilities.
yeah.
And it will convey better if I refer them to you.
Yep.
So my advice to you out there is if you have unmarried people who are about to buy property, always, always, always have them just not guide them, you need to get married or this needs to happen. Just have them have a conversation with an attorney like Brian so they know what could possibly happen. In the case of married people and they want to
Yeah,
know, they
you
have multiple properties.
don't even want to try
Still,
to explain it. Just
yeah.
say, all you have to say is that if you know they're unmarried, and you can say this for most people, I mean, even if they're unmarried, that can be occur in a variety of forms.
Hmm.
But it's just to say, hey, when you're talking to the attorney about the transaction, make sure you discuss how you want to hold title to the property.
Yes.
Don't try to answer it and explain sort of some of the
The difference between tenants
and
and
if you needed
yes.
a primer to be able to have a conversation while not conveying actual legal advice, like I could talk to you about that, but it's not even something you want to kind of dip your toe into.
Right.
Just,
Refer them.
it's a lot of the stuff in your transaction is not going to be you doing something for them or you giving them the answer. It's going to be you pointing them in the right direction and then you putting up a sign and then you reminding them that, hey, this is what I've told you before, so make sure you're doing it. Because it's like, can't make, all you can do is lead the horse to water. You can't make it to drink. You can't make it. It's one of those where like
Hmm.
you just have to consistently be giving the correct, information so that they can make best decisions for themselves.
I agree. So refer your clients for all title questions to your attorney.
Yeah.
Um,
All right, I'm breezing. I'm going through these. Let
okay.
me not cut your face off. Um,
Well, I,
all right, Section 13, those delivery of documents. This is boring. The biggest thing here is that, stuff can be docu-signed. It's okay. This is the complete offer I'll put together.
mhm.
And everything's got to be put down into writing.
Okay.
This is boring. No recording just means you're not recording this document. This agreement does not get recorded, does not become the final thing. The final thing is the actual conveyance of the deed and signing over that and the signing the settlement statement. The only important thing to note is that if there is big important stuff that you have in this agreement of sale, make sure you're talking about it during the transaction so that it's actually being effectuated.
Mhm.
Yes, this agreement could still be acted upon and sued upon if there was some breach outside of closing or that something along those lines, but this is not a public document. This is strictly for the parties and the actual people facilitating the transaction, like the attorney, the attorney, the home insurance, anything else like that.
Mhm. Fair housing.
Fair housing, you can't discriminate. You can't discriminate. You
The
can't
end.
discriminate. You can't discriminate,
And if
and
you weren't clear,
you
can't
can't
discriminate.
discriminate. And that's just you cannot, no, no, no. But to the extent you need to have conversation with clients, you absolutely can, and you can refer them to this section. This is a sensitive topic. Somebody you can obviously entail work with your older agents for guidance on those if something like that came up to you. You just want to be extremely cautious for yourself as agents. Um, if you're seeing anything that could potentially be violating fair housing
Mhm.
laws, that you are not putting yourself in a bad position.
The best
Uh,
way to not discriminate is to make sure you're doing the same thing each and every time that you have a client.
correct.
You're saying the same things each and every time you have a client. Yes, there are going to be nuanced things during the transaction while you're showing houses, things of that nature. You just want to make sure that you are saying the same thing each and every time to all of your clients.
Yep.
The minute you change up is when you may have a problem.
Yep. Section 16. This is really for sellers more than anything else. This is a disclosure to them that they could owe money to the government for selling the home. If you are not a U.S. citizen and you own property in the United States, you are subject to FERPA. There are convoluted rules there. It involves the IRS. I'm not going to try to get into it, but basically, you could be paying a chunk of money going out the door. And there's a Delaware tax payment, which you'll see usually is referred to the Delaware 5403 form. That's how it's described here. It's formerly the 5403. I still call it that. If you're not a state party and you're selling property in Delaware, you could owe money going out the door. You want to point this out to your sellers who you think are out of state so that they know if you know someone's a foreign national, you should have a conversation with them up front so they are seeking accounting and or legal representation because no matter what, I have someone's a foreign national, I have to send money to the IRS. There's a percentage I send based upon circumstances. I send it to them. I have to send it to them, I think, within 20 days of the transaction closing. I do nothing else, but I have to send it in order to protect myself and the buyer because it's technically a buyer obligation.
Mhm.
The seller is going to have to deal with it with the IRS after the fact. I can't do anything during the transaction for their benefit, but knowing it up front for your sellers is going to make things a lot better. And again, some because different sellers are treated differently in how they process things. But if someone's owning an investment property and they don't live here, there's just some good sort of alarms to say, are
Hey.
there going to be taxes paying on the way out the door?
Mhm.
This section, homeowner's warranty, is completely useless. Uh, I'm sorry. It just says that home warranties exist, and if you don't include them here, that they don't happen. The only thing helpful that I find here, because for me it's a bit of marketing, just being honest with you. My biggest thing, if it is in the listing in the MLS or whatever that a home warranty is being offered, you better put it in the contract.
Mhm.
Do not just leave it open-ended and say what was in the listing.
That's not the
Have
contract.
That's not the contract. And this explicitly says that you're being advised that there's a homeowner's warranty. There could be a larger conversation of this section relative to you know conversations with buyers about how home ownership actually works,
Mhm.
and you don't have a landlord that you get to call when you have problems. And some of that's just a kind of a maturity responsibility question for some people. It depends on who you're dealing with, but
Feels very condescending.
it's it's
I'm just saying
Well,
how you're saying it.
you've had the client who has rented for a long time
Mm-hmm.
and something
Mm-hmm.
breaks, and they want to call someone and say, who's responsible for this?
You.
You own the house.
Yes.
But the seller sold it to me. He's like, no, you own the house. That's what this is for.
So this is,
Homeowners warranties can help,
yes,
but there's still work that has to be done. Even with a
and it's
warranty, there's
still
usually
a
money that has to be
responsibility.
paid. So, um,
So your homeowner's warranty conversation also something that should be happening during your buyer's consultation. All right, 18, risk of loss.
if the house falls down or gets burns down before you actually buy it at closing, that's the seller's problem now. And
Okay.
basically, you can terminate the contract, or you can kind of work something out if you wanted to. But it's not yours until you actually sign the paper. And
Mm-hmm.
once you do sign the paper, then that's now your problem. Kind of like I said with the last one, but
Buyer's
not
response.
a ten trying to be condescending. It's just a statement of fact.
I know. So, seller is responsible for the to keep and maintain the condition of the property while you are under contract. If you are under contract and it's a bad storm right before you're scheduled to go to closing, you go and do your final walkthrough, and all of a sudden there's a hole in the roof. That is a seller problem. Sounds like from what Brian just said, you have the right to terminate or come to additional agreement with the seller. But the just because you're under contract and a house was damaged doesn't mean you have to follow through, is the takeaway I want you to
Hmm.
take from 18. 19, condition of property and inspection.
One of the biggest fights we get into is section 19. The basic gist of it is that um, you have to, deliver the property in substantially the same condition as it was seen during the, initial. Uh,
Offer
that
period.
kind of refers back to the one before the risk of loss. If there's suddenly a hole in the roof, like you got to fix the hole in the roof.
Hmm.
Um, the contract does say like it should be sort of, I think was it broom swept? I
Here it
think is
is.
the
Yep.
terminology. Yeah, broom
Broom swept
swept.
clean.
Um, there's a lot. The problem that I see usually is that there's not always correct expectations for what broom swept could look like. And that could be from both parties, buyers and sellers, and there can be a dispute in those regards. If I have a recommendation relative to this section, is be mindful in how you want to do your final walkthroughs.
Hmm.
I think it's 48 hours is the earliest you could do. I wouldn't push it out that far necessarily, just because anything could happen in that 48 hours.
Hmm.
So if you did it at 48 hours, you probably want somebody to go back, like the agent, you as the agent, just to do like a quick right before check in
Hmm.
case something else happened. But it's also not necessarily advisable to, if you close at 2 o'clock, you're scheduling your walkthrough at 12, because one, you're going to be late for closing, and I'm not going to be happy. But
All is about your happiness. Keep
yeah,
going.
I know. I'm this presenter. I get to say what I want. Um, it you don't necessarily set yourself up for success if there's an issue that has to be addressed in
Right.
such a short time frame.
Hmm.
Now, if things have to be addressed, they have to be addressed. I'm not trying to shirk responsibility for anybody, but it's just something to absolutely be mindful of when this happens, because you have to operate on the assumption of, not the assumption, but on the possibility that we're going to walk out of this and I
Hmm.
have to make some phone calls. And that's a lot easier to do if, hey, we're closing tomorrow. It's now 5 o'clock and we're closing tomorrow at noon. We have some time to work on this, as
Hmm.
opposed to it's 10 a.m. and we're closing at noon the same day. Then, we're all held hostage until we can, come to some agreement.
Right.
And,
And it
whether
just
someone's going to cooperate or not, is its own thing, and
And it
that's its
just
own
leads
responsibility.
to
Yeah,
it leads to bad feelings for all parties
yeah,
because everybody is feeling like, oh, well, you should have had this done, and well, why did you wait to the last minute? So
yeah.
it's good to
That's the
be.
biggest thing of somebody moving out, and just kind of with your buyers, kind of explaining what they should expect to be seeing, and also there's sometimes not enough coaching done with sellers for, this is how you need to leave the house.
I agree.
You can't, you can't destroy the walls moving all the furniture out. We are going to have a problem if you do that. You can't scratch up the floor. You can't just leave all of your stuff in there.
You can't just leave
Once you are closing the
trash in.
door and locking it to go sign papers, effectively you are no longer going to be owning that home pretty
Mm-hmm.
darn soon, so you don't get to leave anything there.
Mm-hmm.
And if you're going to leave stuff in there, I I always say tell them in advance. They don't want to find it out the walkthrough. Like the most common thing, you leave some extra paint or a little
Mm-hmm.
extra flooring or a little extra tile or something like that in the
Mm-hmm.
house. That's a nice thing to do from my perspective.
But you still want to
But
give
people are
like,
different,
yes.
and some people won't always appreciate that. So if you know the seller is going to intend to do that,
Mm-hmm.
and hopefully part of your conversation with your seller is, hey, what's your time frame for moving out? So you know everything is going to happen in a timely manner. If something's going to be left, have that conversation.
All right, so I'm gonna do wood destroying insects report. People like to say termite, termite, termite. Wood destroying insects includes termites, but not limited to. So make sure that you're giving yourself enough time. Your wood destroying, your WDI can be done at the same time as your home inspection. However, make sure you're putting a date here. Don't just leave it as the default within 15 days of ratification. Don't do that. Put an actual date here. Decide whether you're getting it or not. A lot of times I see a date here, but none of these boxes are checked. Take your time, less questions. All right, going into, should I go into like manufacturing? I don't need to do that, do I?
No,
Okay.
no, you're good.
All right. 21, home inspection contingency. What I like about the Delaware contract, and correct me if I'm wrong, is it is very specific to majors.
Hmm.
Whereas other contracts in other states, like you really could be asking for cosmetic things. Delaware is very specific and like, hey, if it is listed as a major on a home inspection report, then we can have a conversation about it. The problem comes is when where your home inspector is listing everything as a major. That's when some parties are going to become irate and upset. Like this is a minor thing. There's no safety hazard, so on and so forth. Some of you agents are going to be out there and you're going to be a lot more experienced and you're going to be able to walk through a property and say, hey, this is going to be a FHA thing. This is going to be a FHA thing. And you're going to be able to point those things out. If you have a seller and you're a listing agent, you have a seller and you can do that, great. It's a proactive thing to do. However, when we're in this contract and you've selected home inspection and you've put a date here due to seller, don't forget about this date. Send your requests for repairs over on or before this date. Give them time to respond and then have all that stuff wrapped up on that very last date. If you can't agree on terms, then you don't move forward. If you can, then you do. It seems very, very simple. Your seller and your seller's agent are going to have multiple options. They're going to agree to do things. They're going to agree to do a few things. They're going to give you concessions for things, or they're going to agree not to do anything. Those are the only outcomes that can come out from this, in which case it falls back to the buyer and gives them the option to come out of contract. Anything I need to add on that?
No,
Okay.
the only thing, be intentional with your dates as
Hmm.
far as what's actually possible and making sure everyone is on the same page and hitting your marks on there as far as those days go. A lot of this is going to be case by case specific as far as
Hmm.
how it comes up. The best thing you can do in protecting yourself is that you are hitting the timelines exactly when you need to. You can't be responsible or control what the listing agent or the seller or anybody or the buyer's agent does in that situation. So, make sure you're hitting your marks in those situations, and if you're expecting something back from the buyer's listing agent
And they don't send
and
it
they
back
don't
in the
say
time.
anything,
You need to reach out to
then you
them.
need to reach out to them. And
Put them on
if it's
notice.
me, I put them on notice, or you reach out with an addendum that says, due to not providing anything, the inspection contingency has been resolved
Hmm.
because they haven't done what they needed to do. And you're not just sort of leaving it out there and hanging. And again, is it all going to play out pretty? Sometimes yes, sometimes
Sometimes.
no. But all you can do is be mindful of your dates and do your obligations under the contract.
What? And
Why did it turn out? No, no.
Oh, because we were
Oh
in,
no.
that's okay. We know where we
Oh
were.
no.
We can open it again. See how that works?
Hmm.
And then we can scroll back down.
Yeah, yeah, yeah. What's
Um,
next? That was inspection too.
that was, yes, home inspection
Yeah.
contingency. So one important thing that I want to note, I want you to note, if necessary, by a licensed contractor, professional. If that's what your reply to inspection says, that's what you must do. Other inspections, on-site wastewater, septic systems. That's always fun. I'm gonna let you talk about that if you have anything to add.
No, just
Okay.
septics. I mean, septics have to be done every time there's a transfer. Someone has to do the inspection for them. Um,
What are the seller's
that,
responsibilities?
I mean, usually it's on the seller as far as getting it updated and having a cert to be provided in those situations.
Okay.
You always want to do the septic contingency because it can be a huge hidden cost for people.
Mm-hmm.
And
Just
some,
rough estimate. I got an estimate for a new system. It was $45,000.
yeah, absolutely. I've seen that. So you just want to have, and there's, I think if you go to Denrec, they usually have a list of certified inspectors or
Mm-hmm. Yes.
parties who can look at that. But yeah, you absolutely want to be checking that, and it can be a big thing. So most of these is just the other ones. Radon is usually a general for
Mm-hmm.
most people.
Mm-hmm.
If there's not a swimming pool, you're not doing a swimming pool contingency. And if there's not a well water, then you're not doing a well water contingency. If those things are there, yeah, you should have them done. But if they're not there, then obviously it's not really going to be applicable for your transaction.
So, where would you be putting if you were getting a sewer scope? Would that go under home inspection or will we be writing that out?
Um, I would probably write it out separately.
Okay.
Um, even if you didn't have to do all of it, I mean, if it depends upon your time frames of how you're going to do it. Like you wouldn't want to, if you're doing sewer, you don't want to mark in their septic. If you're doing sewer, you don't want to mark them in well. So like
Mm-hmm.
I would make it on its own thing. You can make it subject to other dates in the contract for
Okay.
simplicity purposes, but I would set it out kind of individually in those regards.
Okay. And this section here just outlines the seller's duties and the
Mhm.
buyer's duties, and it explains in clear and I feel like plain English. Once you get a response, what the buyer, what you, oh, once you get a what a buyer can do, what their actions they can take, whether they can accept the terms, whether they can back out a contract. It explains it in plain English. If there was one section I would have a buyer place specific in attention to, it would be this one.
Yeah, no, absolutely. Because that's just it's an attempt to be a practical explanation of how that plays out.
Hmm.
And some of this stuff that we go through is just going to be hey, the seller's relying upon you as the agent to explain it.
Yeah.
Again, you always want to send these to them so they have the opportunity to review them without the context of a pending sale, but just to know the terms. But some of them, like they're ones that like I would want you to like copy and paste and be like, if you read nothing from this, read this because I need you to actually understand. Because some of the inspection stuff, by some, I mean a good portion of it is just an expectation, sort of,
Hmm.
lack of, connectivity as far as what the expectations do,
Hmm.
what, should actually occur. And that's when we can end up in problems a lot of times when there's just there's unrealistic expectations of what this is going to look like.
And
It's
why it's a
not.
good reason to do a trial close. So
Yeah.
before even getting under contract and them seeing these documents for the first time, you've done a trial close. So they've gotten a chance to understand like what these sections mean. So environmental conditions, asbestos, soil testing, um, what other environmental concerns could there be?
um so essentially what this says in the large part is there are some things the seller's not going to be able to know about. And if you kind of want to do general sort of environmental testing, like you need to come up to a separate agreement. So it's sort of in the same realm of like if you're doing a sewer scope of like if you need to do a some environmental testing of the property because
Mm-hmm.
of your particular use of it, or you have a concern or whatever else, like set
Lead-based
that
paint
out
or
as a
something.
separate
Mm-hmm.
thing. Not even and lead based. I think lead you kind of can.
So there's no, not on a contract, but there is
Yeah,
the lead-based
yeah,
disclosure,
yeah,
but
yeah.
that
So,
would
but if
fall
you
under
want to do a
this.
specific, like specific environmentally focused tests,
Mm-hmm.
you would be addressing it in specifically in the
Mm-hmm.
contract to say, I want to do this kind of test. Um, I know it lists radon in there, which is kind
Mm-hmm.
of redundant because there's its own radon test, but like you're basically saying, like, I know I'm going to want to do one because of, let's say, a common thing of uh, there you have a child who has, either allergies or asthma. So like
Mm-hmm.
you need to test in advance for certain environmental factors that the seller may know nothing about
Right.
because they're not as sensitive to it as your child is or as you are.
Mm-hmm.
So you are going to want to do these things because you need that in order to be able to live in the home. You
Mm-hmm.
need to specifically be telling them, hey, I want to do this thing. Um, that's something kind of some of those outside or additional inspections that you want to have happen. You just need to know what you're going to want to do up front.
Mm-hmm.
And sometimes it's based upon the property, sometimes it's based on the client. But like, if you know you're going to want a structural engineer to come into it, and I know part of the agreement talks about that, but like,
Mm-hmm.
hey, it's an old home. The home was built in the 1870s. I'm going to have a structural engineer come look at this house before I touch it. And you'll see some of that in certain parts of Wilmington and throughout the state contract to do that inspection
Right.
specifically
Mm-hmm.
rather than, oh, we're just going to do it under the general inspection. So, no, 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 no. We are going to have somebody out there specifically for this reason. The
Yeah.
seller's going to know about it. And if it falls through because of this, they're going to know why it's because of this because we contracted for it.
Yes. Buyer's defaults talks about what happens if.
Yeah, you default. So you're not paying when you're supposed to. You're not following up with the lender. You're not providing information for the transaction. Then you have defaulted.
You provide false information.
Seller's default is typically more along the line of just refusing to come to closing or provide information relative to the transaction. Basically, what this is about is legal remedies. So generally, the deposit is going to be the sole legal remedy. The mutual release, the standard one, releases everybody to everything.
So you can't
And
come back
it's
later.
correct. And it can cover everything. So sometimes there could be damages outside of just or greater than a deposit you want to be considerate of.
Mm-hmm.
It does discuss sort of the obligation or the not the obligation, the ability to seek specific performance,
Mm-hmm.
which is forcing someone to sell. It doesn't happen, but it does happen. I literally just read a case about this that happened.
Mm.
It got decided about a couple of weeks ago for a property down in Millsboro. So like
It can, it's
it's
possible.
convoluted, it can be expensive, but it does happen. And part of the reason why you want to have your contract buttoned up is that if everything goes to heck, you have a fully enforceable ratified contract that can be sued upon, and your client is able to
Mm-hmm.
make themselves whole and buy their home because in the specific case that I'm thinking of, the people had sold their home in another state and then were coming 2 days later to buy this house. And the lady said no, and then they've sued to force the sale. And I mean, it's been hard for everybody, I'm sure, in that transaction, but
Mm-hmm.
it's a thing that does exist as a remedy to the buyer. Usually less so the seller have a remedy to force performance of a purchase, but to my knowledge, let me look at this again. Um, it can be, sort of, I think it is technically a remedy underneath of it. It's harder to do. Um, no representation. You can do that one because that's all about you guys.
Mm-hmm. Buyer and seller understand and acknowledge broker or designated agents is not at any time authorized to make any representations about this agreement or property other than those written in this agreement. Brokers, designated agents, sub-agents, and employees of brokers do not assume any responsibility for condition of the property or for the performance of this agreement by any or all parties hereto. By signing this agreement, buyer and seller acknowledge they have not relied on any representations made by brokers or any agents, sub-agents, or employees of brokers except those representations written in this agreement. So for me, if you're representing a buyer, you better have a buyer's agreement. If you're opening a door for a buyer, you better have a buyer's agreement. If you're representing a seller, you need to have a seller's agreement. That is the person you represent, the person that you have an agreement with. If you have no representation agreement with someone, then you don't represent them.
Mm-hmm.
You cannot make any statements, acknowledge anything. You can't do anything on their behalf because you do not represent them without some type of representation agreement. And I feel like that's the same with attorneys.
Mm-hmm. You have
You
to have a formal agreement. Just having the conversation with me doesn't mean that I'm your attorney. So
so
I can do this, and it doesn't mean I'm not representing anybody. I'm just giving information.
so if
But
I
to
gave
actually
you a
be signed
dollar
off,
right
yeah,
now, like they do in the movies, that doesn't work.
it's kind of works. It's not like a full. It's more nuanced than that.
Oh, okay. Because I was thinking like I could pull out like 50 cents because I'm not really sure you're worth a dollar.
Yeah, that's true. That's fair enough.
Okay.
Um,
Agency disclosure.
no, do you do indemnification attorney's fees?
No, you do that.
Okay, so short answer
Mhm.
is you as the agents and the broker um, are not sort of you're you're just acting as agents for everyone. You're not sort of taking formal action, so you're not necessarily liable under things in the agreement.
We're not like the power of attorney.
Yes, yeah, correct. So it's a lot of times it's really for the broker as far as they're operating above you, and the actual brokerage is not responsible for an issue that comes up in a transaction. There's a general protection for agents because usually it's going to be if there's a bad faith actor, typically it's going to be a buyer or a seller, and that's when we had a problem. So it's really a protection for you guys. The biggest thing that comes out here is the right to collect attorney's fees. So if there's a lawsuit because of this, um, the prevailing party, the person who wins, can ask the court to award attorney's fees. There's always discretion with the court, but without getting into sort of that, it's not standard in contract for the winner to be able to get attorney's fees. So it kind of adds a level of sort of peril of peril for the buyer that, hey, if you don't do what you're supposed to do, or the seller, hey, you know what you're supposed to do, like not only could you lose, you could have to pay to lose. And it's sort of a, hey, this is serious. This is a full legal contract. So there's more than one way to lose. You can lose, and then you can lose really badly.
Mm-hmm. Mm-hmm. So they could get attorney fees, but
Yes,
this is
on
not,
top of.
yes, but it's not saying that you absolutely will.
Yep. Agency disclosure. Please write down this stuff. Just fill this stuff in. This is not complicated. Sorry. Um,
Brooker.
Biotic compensation and
So,
stellar concession. I'm gonna let you do those two.
so the reason why the new contract, this as of, after the settlement and things of that nature, this section was not on the contract before. This has been added, and this is what you're negotiating. Whether you're going to negotiate your fee up front before submitting the offer, whether they've already agreed upon this, or whether you're going to submit your offer, this is what you're requesting. Keep in mind, you have to have a buyer's agency agreement. If your buyer's agency agreement says that you are requesting 3%, and I don't even want to give a number, I take that back. If your buyer's agency agreement says you're requesting a certain percentage or a flat fee to do this transaction or to work with this client, that is number one. What's agreed upon in this agreement is number two. If what you're agreeing to on this contract is more than what you've agreed to in your buyer's agency agreement, the buyer's agency agreement supersedes. You cannot get more than what you have listed on your buyer's agency agreement. Seller concession. Seller agrees to a credit of that credit could have been agreed upon before. It could be agreed upon during the commission of this contract. It could be for a lower price. It could be for seller's concession. It could be towards closing costs. It could be towards paying down their rate. That is going to be a conversation that you are going to negotiate as a buyer's agent with a seller's agent. That is the seller's concession to the buyer. The concession couldn't go towards buyer's closing costs at settlement, including but not limited to prepaid items, appraisal, inspection, survey, mortgage fees, transfer tax, or other fees or charges. It is the buyer's responsibility to confirm with the lender that the entire credit provided for herein may be utilized. Meaning the buyer's LO must say, okay, this is a legal credit. It can be used for these things. So you are going to have a conversation with the LO to let them know that this is what the seller is offering. In the case of certain types of financing, there is a max amount that you can get as far as seller's concession. Have that conversation with your LO. Succession. That is going to be you, Brian.
So, what's the fun way to say this?
This is going to be interesting.
So the only thing, sorry, what's helpful here is that if you want to assign your contract to the buy from a buyer's perspective, you need the seller's permission to do it. But a trick for that for your buyers is to write their name and then write successors or assigns after it, because that's technically a disclosure in section one, which is what this is calling for, is to say that, if someone's going to buy it in their personal name, but you're pretty sure that they're actually going to, they put their personal name on the contract, but they're likely going to take it in the form of a trust or like an LLC. You would probably see this in someone, wants to buy an investment property and they'll submit the offer under their own name because that's the only way they can actually do the disclosure of financial information to show they have the money to do it is in their own name because that's going to be on the bank account. But they have this LLC they're going to take the title of the property in and they think they're going to put it into it. I would put and or signs and or successors and assigns on the first page of the contract as a disclosure to sort of tell the listing agent we're probably going to change who the buyer is at a certain point.
I have a question about that.
Yep.
You know what the question is, don't you?
No.
About wholesalers, because that is, I feel like the
Wholesalers. So this is why wholesalers will not deal with the regular contract.
if
Generally, is that they will use a modified of their own contract because they don't want to deal with a provision like this. Or the provision that they have in their own contracts for succession usually will say we can assign it whenever we want to for any yada 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 yada. So usually if the buyer's going to take it differently. The other purpose of this section is if someone owns the home and they put it on the market and they sign the contract and then they die, that contract is still valid and can be imposed upon their estate and heirs. Obviously, there's a lot of practical considerations there that would have to be walked through if that happened. But that is part of what that says, and that's kind of it's what the good and bad of this agreement is that some of this stuff is kind of obvious on the face of it. But some of the stuff is not that obvious. So like that succession section is two wildly different things, talking about the buyer's ability to assign the contract as well as the imposition or sort of that, just essentially death can't be an escape for the seller. That's kind of I know, but it's pretty dense for a two sentence section. And that's a lot of this agreement of sale, which is why I can do a bunch of these and Tiffany can do a bunch of these, but you have to kind of keep reviewing these and kind of reviewing them in different contexts and different lights and how you're thinking about it, and not necessarily in of this part of the transaction or of this one or in light of a particular transaction, sort of kind of some of the things have to be read on their own because they're not going to change generally between between your one contract to the next. So you have to kind of realize that there is some nuance. There's an attempt by this contract to do a lot in a little bit of time.
Hmm.
If
So
you
when
wanted to
it,
pay an attorney for like a commercial agreement that said all of these things, it's 30 pages.
hmm So if the situation calls for it, you're dealing with environmental issues, the seller's sick and they could possibly pass on. These are things that you want to have your attorney on standby to have these conversations because I've been in a situation where the seller passed away. And because the agent was so open and the seller was so open and sharing this information, like, hey, we want to move forward, the heirs of said person, like we were able to move forward even though the seller passed on.
Mm.
I've also been in a situation where there's been some environmental issues and we had to work through those. So if you have those issues, don't try to say, "Well, I understand the contract because I listened to this video and I've talked to a few people." Have a more in-depth conversation with Brian because he's going to be able to give you your case
Mhm.
information
Yeah.
because every situation is going to be different.
Yeah, and speak with your other agents. Somebody's, likely dealt with something, if not the same, similar. So you want to, use the resources available to you
Yes.
because, there are all sorts of different scenarios that can arise.
Hmm.
And, sometimes the answer is just, I need to take a step back, be reflective on this, talk to some people and kind of, develop a plan so I can best advise my client. Because yeah, you can always say we have to see what the contract says,
Hmm.
but there's layers in how it actually plays out.
And what other documents come
Yeah,
along with it.
yeah,
And that's where we are now.
yeah.
Addendums. So
Addendums.
And this is where it gets fun, guys. So, addendums. If any of these boxes are checked with your contract, they are part of the contract. I'm going to say that again. If any of these boxes in section 32 are checked, they are a part of the contract. Period. Seller's disclosure of real property and condition report unless exempt by state law. Blah blah blah. When is it exempt by Delaware state law?
There's a couple of situations. It's usually going to be like an estate sale where the person never lived in the home and doesn't have any information. If it's a bank sale, the bank doesn't know anything about the property. So those parties are exempt from having to do it because they don't have the information to actually be able to give you.
Hmm.
So the law is not going to require them to provide you some notice about what exists.
So in the case of an estate sale, I just want to, because this is a common thing that comes up. An
Hmm.
estate sale comes up and it's being sold by the children, but the children did live there. Is there
Yeah,
a time frame in which they can say they're exempt? Because
not
the way I,
necessarily. It's just based upon statute as far as like if you're heirs to the property, like you're going to be exempt from having to do it. What I will say is that from a seller's perspective, the sales disclosure is a good thing
Mhm,
because if you disclose it, then and it's a problem down the road, you have no liability because you disclosed it.
mhm,
While there is an exemption from having to do the form, if they actually knew about a problem because they live there
mhm,
and then still said nothing,
mhm. That's a big
that's a
problem.
problem. So, there's give and take in that situation. It's all incredibly situation
Situational.
specific. Um, but if you see that, it should just be sort of an
Disclose.
alert for you if you see that they don't have a disclosure and because there's a form that gets signed that says we're exempt.
That's where I was going with
If you
that.
see that, then that should be your alert to say, okay, I need to put on my investigative hat
Yes.
and figure out what I can figure out about the property from where I sit. And maybe you ask the attorney, maybe you have an insurance broker you work with that could be able to look at stuff that they look at,
Mm-hmm.
in different systems.
Mm-hmm.
You're looking, into your office,
Mm-hmm.
whatever the case may be, as far as how can you gather information. And some of that could just be asking questions to the listing agent. what are you doing here? Because in some of it, because some of what's in the disclosure is not just, hey, we did this with the property, or hey, this was the problem. It is, this is how things work. This is where the utilities come from.
Mm-hmm.
This is what
Mm-hmm.
information we have. So
Mm-hmm.
if you have that checklist or that sheet for yourself that you have for your internally that says, this is all the information for the home, you
Mm-hmm.
could send that to listing agent and be like, can you fill in any of this so we have an understanding of who does the water, where's the sewer, what type of, use of the property is. I mean, they'll put some of that stuff online, but you're better off asking the question. And
Yes.
I mean, and someone's refusal to give you any information is an answer in itself that you have to be cognizant of and that you have to, tell your client about to be like, they're just not giving me anything. Well, that could be an influence to how you want to proceed or not proceed with the transaction.
So on
Ask
the
questions.
so with the seller's disclosure, it's not saying the form itself is exempt. It's saying that the filling out or the completion of the form
It's the
can be.
completion of the form, yeah, because the completion of the form is required under law under
There
Consumer
we go.
Protection Acts.
So know that if you have a seller that's saying, "Hey, I never lived here. I bought this property as an investment, blah blah blah." There is, I believe, the second to the last page where they're going to sign, saying what we just said. Also, with the seller's, I'm sorry, the lead-based paint disclosure, addition also says could be exempt by law. It's not the form that is exempt, it's the completion. So on the top of the lead-based paint disclosure, LVP, it will say house built prior to 1978 or after 1978, or I forget what option three is. One of those two boxes will trigger more information. If it was built prior to 1978, it's going to trigger that your seller has to complete the following sections. Once they complete those following sections, then you're all good. If they say that it was built after 1978, they are just going to initial. Okay. So, lead disclosure. Also, same situation. You're going to enter the information that you know. Um,
Resale cert is when there's an HOA or condo. There is I'll see if I can find it and Tiffany. There's a really great form that's prepared by the Sussex County Board of Realtors that kind of talks about the flow chart of when
mhm,
this is applicable. It's more common in Sussex because we have sort of those big HOA communities.
mhm.
You will still see it here. It's a seller requirement. It's information the seller has to provide for the transaction.
I will put it
And
as
any
an attachment to
Yeah,
this video.
yeah. But anytime you have kind of an HOA that's a formal HOA of it has a management company, I'm going to warn you guys, as if you're a listing agent, seller's probably going to have to pay some money for them to give a disclosure or an estoppel certificate of some kind, even if it's not a full resale certificate, for us to move forward with the transaction. That throws off a lot of agents when they're like, why are we getting charged $100 for this form that doesn't take any time? It's the only way I can get information for a transaction. That's not under resale, that's its own thing. But resale is when you get the sort of particularly newer communities post 2009 where there is a formal sheet that they give you. Lenders are going to need it. It gives insurance information about bylaws, but it's really helpful. But I'll send her that form that kind of lays out where you could expect to receive something like that. Tax deferred exchange. Find out. This is just a conversation. You don't get to just do a tax deferred 1031 exchange when you want to.
Mhm, mhm.
That's not how they work. They have to be planned out. There has to be a 1031 exchange or
There's a timeline
there's a
involved.
timeline involved. If you're a seller, you have to identify the property. The money has to go to a third party.
That's a
Um,
separate class.
yeah,
We can go
so
to
that's what I
that.
mean. It's not a, oh well, we might do it. No, it has to be done. And if you're the buyer who's completing a 1031 exchange, you're just clicking that box because it's basically telling you and telling the buyer's attorney we're getting money from an exchange, or and guess what, everyone's going to have to sign some extra forms because it's a 1031 exchange, and we don't want someone complaining about it because they got to sign a couple extra forms.
Right. Buyer's financial information. We don't see that a lot here in Delaware. Sometimes I shouldn't say that. If you're buying a property and you're buying a property cash, that's usually when we're going to see more of your
Yep.
financial information. So that's what,
Just be very cautious as the agent if you're getting like the screenshot of the account. Make sure that you're taking the time to either
do more dig. Yeah.
black some things out or something because you're not trying to over reveal information and you want to protect your client's interest and you are in a trusted capacity so that you're not just sort of sending that one out willy-nilly or as far as that's something that they could follow up with you for later and you make sure you're you know blocking
Yes.
off the account numbers or stuff like that. You're just being cautious.
You have to protect people's personal information.
Absolutely.
Mortgage letter with credit check. Usually I see this box checked because it is assumed that the mortgage company has done a credit check. That's how they were able to provide the pre-approval letter. FHA mandatory language and and for your protection, get a home inspection required with FHA. Your VA mandatory language, all also required for VA loans. If your buyer is requesting or if your buyer is getting a home warranty, the information will go here. Homeowner's warranty paid for by buyer or seller and the company name. Additional addendums that you would have listed here. We talked about the escalation clause. There could be, that environmental language. That could be additional buyers. It could be additional for these purposes. It would be additional buyers. That would be on addendum or any other addendums that would go along with this agreement of
Mhm.
sale. Additional contract terms.
So that's kind of where people get creative. What I would tell you is that um, that's usually where you would see used to see seller assist that's now built into the rest of the agreement of sale.
Mm-hmm.
Um, sometimes you'll see provisions there relative to property that's to be kept or not be kept. I think
Mm-hmm.
that properly should go in the exclusion inclusions chart.
I
It's
think,
kind of sort of those other things that have to be detailed out in some way, shape, or form. This is kind of where people can get a little bit overly creative and provide a little bit too much. But it's kind of the if you are dealing with this square peg and all you have is round holes, that's where you address it in section 33 to kind of um, it's a source of flexibility as necessary for your transaction to be able to move forward. So it's just something that you want to be cautious of that
okay.
because you're not doing too much.
Miscellaneous.
Blah.
It's just, I look at this as like a disclosure.
It's just a disclosure. It just says singular and plural. It's just it's a word vomit of technicality. So
Mm-hmm. Changes. We are real estate agents. We are not attorneys. We do not have the right to we do not have the right to strike through contracts, create language that we are not licensed to do that. So if you're writing up an agreement to sell and your client says, well, I don't like the wording here, I wanted to say this, you do not have the right to do that. If you want a specific contract built out for you, you have to contact an
yeah,
attorney. The end. Um,
just entire agreement, same thing. This is sort of the technical legalese stuff of saying it's the complete agreement. There's nothing else sort of as a side accounting for addendums, but like that's sort of the hey, we had a conversation about it, and well, if it didn't end up to the final agreement, then it's not a part of it. If it was in the MLS listing or the online listing and it's not actually here, and there's no default like the seller's disclosure is his own item, but it's not part of the agreement. It is this. So there's nothing that gets said or verbal. It's what is put on this paper, and the associated addendum is the final agreement. And it's not sort of final until everyone has signed it. And that's the main gist of it.
make sure all the information is completed in
Please
this
do.
section. And that includes the listing agent code. The listing agent code is going to be found in your Bright MLS. If the listing agent or you yourself as a buyer's agent are not in Bright MLS, you're not going to have a code. That would be the only time it would not be in there. But your license number, your broker's license number, your office address, with suite number, also require your phone number, your email address, for both you and the co-oping agent. Even if the co-oping agent is in your office, both sections need to be completed. If the EMD was received with this agreement to sell and accepted, then that information will be put here. Otherwise, if you're the buyer's agent and you're completing this, you're not going to put any information here because you're not receiving the EMD. And that, my dears,
That is that.
that is the
So
end of this presentation. Brian is
I
going,
have to go. I have
yes,
to hurry. I would be more than happy if Tiffany will agree, because as you can kind of figure out, Tiffany and I, we like talking to each other.
I don't know if that's
If
true.
you want to do like if there's a mailbag, if there's a bunch of questions after the fact, if as you kind of gone through the video, um,
Just
there's some
email.
stuff you want to do, you want to focus on, we are happy to. I'm happy to answer your questions if you have for me when you see me in the office. But if we hopefully get enough feedback, we can kind of do
Fireside chat.
yeah, yep, mailbag chat sort of afterwards, just to kind of go over that. Maybe we can hit on some of the addendums or something like that
Mm-hmm.
if there's something we couldn't get to. Obviously, I think we went a couple minutes longer than we intended to, but
I
I
think so.
think there was a lot of useful stuff in there. Um,
Always refer back to this. And like I said, there was
yeah,
that one section. If you wanted to, we talked about wire fraud. That one section, that wasn't for you. That was for you to understand, but that
yeah,
really was for your client. If you want to take that snippet and put that in front of your client, totally okay with
yeah.
us. But if you want to go into a more detailed discussion and we have enough people, sure, we can do this live, but you can definitely send us your questions, comments. I'm Tiffany Rademacher with the Buy Sell Rent team at KW Empower and KW Cherry Hill. Really focused on Delaware because that's where we are and that's where Brian covers.
That's fine.
Brian Riggin with Parkway Law. Brian, what's your cell phone number? I mean, what's your office number? I'm sorry.
302-449-0400.
Can you say it slower for the
Three
people?
zero two
Mhm.
four four nine 0400.
And your email address?
It's Brian, Brian, at Parkway, PARKWAY dash law, LAW.com.
By the way, this isn't a phone. You shouldn't put your phone directly. Whoa. I
Why?
mean,
See, we did
we
so well.
so
We did so well, and you blew it at the end. You
All right.
had to try to get me at the end, and you did. Congratulations. Congratulations. Thank you. Bye
Thank you.
bye.